The following presentation has been designed to provide viewers with an overview of art and its interaction with the law of delict in South Africa. For more information or references to authority for such information, please refer to the art law booklet. In this presentation, it will be illustrated how art has the possibility to infringe two personality rights, which are found within the realm of the law of delict, namely Dignitas and Fama. Dignitas, for our purposes, refers to dignity, and Fama refers to reputation. In the law of delict, there are several actions in terms of which one can claim compensation for harm unlawfully caused to them. One such action is the actio injuriarum, which is used to claim for non-patrimonial harm caused as a result of a personality rights infringement. Therefore, a plaintiff would use the actio injuriarum to claim for an infringement of their dignitas or a Fama. In order to successfully claim under the law of delict, the following elements need to be satisfied: harm, conduct, causation, wrongfulness, and fault. Fault can be either in the form of negligence or intention. For purposes of proving an infringement of dignitas, only fault in the form of intention is sufficient, whereas for the purposes of proving an infringement of Fama, negligence may be sufficient if the defendant is the mass media. The first personality right that will be discussed is dignitas. In this context, harm, conduct, and causation are manifested in a factual violation of the plaintiff's feelings, which the plaintiff must prove. Should the plaintiff succeed in proving that there has been a factual violation of their feelings, a rebuttable presumption arises in respect of wrongfulness and fault, and it is thus on the defendant to rebut that the elements of wrongfulness or fault have been satisfied. To prove conduct and causation is not problematic, and thus only the requirements for the proof of harm by the plaintiff will be discussed. It was held in the case of Roux versus Day that the conduct of the defendant has to be both subjectively and objectively insulting. So not only does the plaintiff have to prove that they were personally insulted, but also that the reasonable person would have been insulted. In order for the defendant to rebut the presumption of wrongfulness, the defendant needs to prove that it isn't reasonable for the court to find them liable, taking into account legal and public policy considerations. One example of such policy consideration is that politicians are expected to endure a greater amount of criticism than the reasonable person. In order for the defendant to rebut the presumption of intention, they must prove that they either didn't have the direction of will or the consciousness of wrongfulness. In other words, the defendant must either prove that they didn't intend to cause the plaintiff harm, or that the defendant was not aware that their conduct would cause harm to the plaintiff. Several defenses are available to the defendant to prove this, namely that the defendant made an error or joke, or that their conduct was as a result of intoxication, provocation, or emotional distress. The second personality right to be discussed is Fama. It was held in the case of O'Keefe that a person's reputation is here meant that character for moral or social worth to which he is entitled amongst his fellow men. Fama can thus be distinguished from dignitas on the basis that Fama concerns what other people think of the plaintiff. An infringement of Fama manifests through defamation, which has been defined as the wrongful intentional publication of defamatory material that refers to the plaintiff. Again, as it is with the infringement of one's dignitas, once the plaintiff has proven a factual violation of their right to Fama, there is a rebuttable presumption in favor of wrongfulness and fault. Conduct manifests in the form of a publication, harm in the form of the material published being defamatory, and causation in the form that the defamatory material refers to the plaintiff. Publication has two elements that need to be met: communication and understanding. This is because if the material is not understood to be defamatory by the reader, then the reader's perspective on the plaintiff will not change, and there thus cannot be defamation. Whether or not material is defamatory depends on whether or not the ordinary meaning of the words used are known to be defamatory. We are concerned with the ordinary meaning because the test is an objective one and asks how the reasonable person would have conveyed the words or conduct. Defamatory material can refer to the plaintiff either directly or indirectly, but should reference to the plaintiff be indirect, it needs to be asked whether the words or conduct are capable of referring to the plaintiff, and if so, do the words or conduct actually refer to the plaintiff? In order for the defendant to rebut the presumption of wrongfulness, the test is the same as for Dignitas, namely, that the defendant needs to prove that it isn't reasonable for the court to find them liable, taking into account legal and public policy considerations. Defense is available to the defendant to rebut the presumption of wrongfulness where Fama has been infringed are privilege, fair comment, truth and public interest, and reasonable publication. To raise the defense of privilege, the defendant must prove that they have a legal, moral, or social duty to publish the defamatory material, or have a legitimate interest in doing so, and the person to whom such defamatory material is published must have a similar duty or interest in receiving it. Fair comment is the right of the citizen honestly to express his genuine opinion on a matter of public interest, however wrong, exaggerated, or prejudiced that opinion may be. To raise the defense of fair comment, the following requirements must be met. Firstly, the defamatory material amounts to a comment or opinion rather than a statement of fact. Secondly, the facts upon which the defamatory material is based are substantially true and are widely known or incorporated by reference. Thirdly, the defamatory material pertains to a matter of public interest. And lastly, the defamatory material is fair. To raise the defense of truth, the defendant must prove that what was communicated was true, and there is a reasonable presumption of falsity. The communication can also be substantially true for such defense to be available. The defense of reasonable publication appears to only be available to the mass media and will thus not be discussed for purposes of this presentation, but has been somewhat elaborated on in the booklet. It was earlier mentioned that if the defendant is the mass media, then fault in the form of negligence is sufficient, but if the defendant is a natural person, fault must be in the form of intention. Defenses available to the defendant to rebut the presumption of intention include error, jest, intoxication, provocation, and emotional stress. In order to disprove fault in the form of negligence, the defendant will have to prove that they acted reasonably. In other words, they acted as a reasonable person would have in the circumstances. This concludes the presentation. Thank you for listening, and remember, for more information or references to authority for such information, please refer to the Art Law booklet.